Talking with Jamie Ritchie, we know things down a bit. So if a vacancy occurs, what does that mean? And when did this vacancy occur? Because it is arguable that because Brian McNamee's death occurred in December of 2015, one might argue that that's when the vacancy occurred. But I'm saying, no, the language of the statute doesn't really look at the action that caused the vacancy. It says, for any cause during the first 12 months of the term. And so,
any causes you're interpreting to include death of...
Right, that's where I think that the drop-down menu in 53 got wiped out. Rather than going through that type of process, it was just wiped out by this legislation.
And what's the issue relative to vacancy?
Vacancy occurs. I'm saying that once you convene as a body and the members are sworn in, that's when the vacancy occurred. Because it was a body and there was no one here to answer the call, the roll for Ward 6.
And the counter argument to that, if you know it, would be what? I mean, there's a vacant chair right there between...
Well, now I'd be getting too far down the road of characterizing things which wouldn't necessarily be fair to Mr. Harris or Mr. Ritchie, but they view it differently, I'll say that much, and it's in writing. It's something he submitted.
Now, what's the weight of our interpretation? If we were to vote, in a legal proceeding, what's the weight of our action this evening on any, if you can speak to it, potential litigation relative to this issue? Is there any weight given to what we?
Well, I think it would certainly, carry weight, whether this legislative body which enacted the ordinance that prompted the special act is going one way or the other on it. I think it would carry weight.
Legal case law suggests you have to give words that are everyday, regular, plain meaning. Certainly, I would hope that if an action that we take based on an opinion that you render relative to the call for a special election, that the action we took, essentially interpreting our own body's precedent, would have some weight in the court. So you think that it would, to some degree, be viewed that way by a judge?
Right. I can very comfortably say some weight. I don't know how much, but if challenged, I certainly would raise it. And I'm sure that if you were to act in a manner contrary to the plain language, then I'm certain that that's something that Mr. McRitchie would be waving around. I know that were I in his position, I would be.
And can you speak to the risk, if any, there would be, should this body move forward tonight with the matter before us and set the special election date?
Well, there's no risk. It's just an act. You're setting dates, and what it'll essentially do is it'll put everyone on the clock. If Mr. Harris wants to challenge this, he'll have to proceed in court. And when we go to court, we'll indicate these are the dates that have been set, and we'll ask the court to cooperate by expediting things. And this is the type of matter that would probably be handled on a briefing and oral argument basis. There aren't any mysteries here.
And you would expect that to occur quickly should a suit be filed?
Yes, it really would have to.
I mean, because one of my concerns here tonight in voting for this, with this kind of dark legal cloud hanging over it, is what that does primarily to the residents of Ward 6. If there's uncertainty, listen, it's hard enough to get people to vote on an election day, come out and voice their thoughts and opinions on an election day that's been scheduled for months with a lot of publicity and a lot of candidates and fanfare, but for a special election to be held on an unusual time in a small part of the city, 1/6 of the city, I think it's hard enough to try and encourage people to vote or to expect them to come out and vote in that election, never mind throwing lawsuits into it that would seek to cancel the election and uncertainty in that. So I think that that's a kind of a risk that we would need to consider as to what, if we take that action tonight, what the ramifications are tomorrow and moving forward. I mean, listen, I'm a lawyer too. When people say, we'll sue you, that it really
Right.
doesn't scare me as much if I think we're on good legal ground. And that's in my day job and in this position as well. If we accept your opinion for what it is, which appears to me to be well-founded on a solid legal basis, the risks are what they are, that someone's going to sue. Someone can sue you for
Yeah, I think the challenge by an individual, or the question, it's not even a challenge yet, constitutes a legal cloud. I mean, this is what happens in democracy, and there's a little back and forth, that's fine, but I think that doesn't mean we stop and pause and wait. I think that we should just move forward in the process. That's the way we can address some of the issues you raised early on about the fact that Ward 6 is now without representation. And the best thing I respectfully suggest this body to do is move us toward a vote by setting the dates. And then Mr. Harris can make a choice. He can either have heard what the body says and heard the discussion tonight and consider his options, and then he'll either challenge it in court or he'll perhaps participate in the electoral process again, or maybe he'll say, I'm not sure, I've got enough. I don't know what'll happen, but I go back to comments earlier that it would be terrific from a taxpayer standpoint and an efficiency standpoint if he were right. But I just think the plain language of a very, short, concise statute is pretty clear, so.
Well, thank you, Ms. Simmons. I appreciate that. And I agree with you. I mean, if we had the luxury of doing the things that were perhaps easiest and in the best interests of perhaps the city financially and procedurally, it would be clearly the choice would be appoint Mr. Harris, allow Ward 6 to be represented or to not go unrepresented for a number of months, save the taxpayers some money. I think that would be the easier course of action. But unfortunately, as a legislative body, it's incumbent upon us to follow not only the law of the state, ordinances of the city, but also to pay deference to, again, those that sat before us and the policy decisions that they made. This is a policy that has gone uninterrupted for 12 years. I've been up here for 6. Councilor Finn, you've been up here the entire 12. I've been up here for 6 of those. I don't recall anyone ever offering a home rule petition to change this. It's pretty clear if you're looking in the minutes, 1984, and looking at the council order 2004-16, January 20th, 2004. I can only imagine that it received a robust debate, given that only 6 of the 9 councilors voted in favor of it, 3 of them voted against it. Going back to 1984, it was unanimous. That council approved it on April 5th, or signed by Mayor McCauley, April 5th, 1984, unanimously passed by the council on April 2nd. These are discussions, these are debates, this is a policy that was rendered by the city council prior to us sitting in these chairs, any of us sitting in these chairs, and I think that we have to pay some deference to that they had a policy decision. They came up with a conclusion and a standard that our community would be guided by, and to not set this special election, I think, flies in the face of precedents from our own body, and really, I would find disappointing that we don't rely upon the fact that there were these policy discussions in the past. I think we need to stand behind the policy, and that's your interpretation is that of that policy is that we call for a special election. And given that, I'm going to support calling for the special election. I can say with some confidence here that the 8 of us are no better suited to fill the empty Ward 6 seat than the voters of Ward 6 are in a couple of months in a special election. I don't believe that anybody's entitled to the seat under these circumstances. And I fully support letting the voters of Ward 6 decide who their city councilor is. And I'll support this, the setting of the date. I also have a resolution on essentially saying the same thing, which we probably don't need to get into later on the agenda, because I suspect it's the same issue. I didn't realize that this was going to be on the agenda this evening when I drafted that resolution, but I'll speak to that later. But I think we leave it up to the voters, not us, to select their representative to sit among us in this body. Thank you, Mr. Jennings. I appreciate it. Thank you, Madam President.
Thank you. Further discussion? Yes. Councilor Finn.
Again, since his opinion has been referenced a number of times, and because ultimately, being up here, I've always felt that this is essentially the house of the people, so to speak. When a person has essentially, for lack of a better term, a petition or an opinion in some respects, oftentimes it's important that they might be heard. And I recognize that this would require the unanimous consent of the body, but again, just so that there's no misunderstandings, what we're really dealing with here is an interpretation of the law. Mr. Timmons is our city solicitor, and I'm prepared to rely on his opinion in terms of setting a special election. But it's just not as black and white and simple as we may think it to be. I know I participated in one of those votes in 2004, and I know part of the intent oftentimes was making certain that it wasn't arbitrarily necessarily determined by a person who happened to come in second in an election for very serious reasons at that particular time as well. And so I see that, but there's a difference that has to be made between sometimes, again, what the intent is and also the articulation of that. Because there seems to be a different understanding in terms of what we're talking about with the issue of vacancy as opposed to, again, this failure to elect, which I think is at a minimum worth understanding, if nothing else, so that we know what's here. So I would request with the unanimous consent that we allow Mr. McRitchie, if he could, simply to present what his opinion or understanding of this was and why Mr. Harris is raising this issue.
Okay. So I think that's in the form of a motion, is it? Or is,
It's a request for unanimous consent. If I don't have unanimous consent, it doesn't go anywhere.
right.
I'd ask for a roll, I'll second that, and ask for a roll call
Okay. Very
vote
well.
on the motion prior to vote, if I could.
Councilor Pellington.
To Mr. Timmons. I'm never, ever going to give you the opportunity to ask a question this way to you again, so do with it what you will. What do you think of the motion that was just offered? And how would you advise me to vote on it?
Well, I'm going to demur on that one. I mean, it's up to the body how you handle things. You know, I'm certainly willing to hear what Mr. McRitchie has to say. I think in regards to this body, it is really not relevant. I think that the ruling of the city solicitor is the ruling of the city solicitor, and that, you know, inviting other opinions, that's really up to the body. But if the body wishes to hear before it makes a final decision, then you should do it. And he's been good enough to come this evening, and he's shared his opinions as well prior to bringing the issue forth. There have been written opinions that have been shared, and discussions occurred between Mr. McRitchie and I, but I would not presume to advise you on this question. This is definitely a discretionary matter.
I've gone on and on about deference to those who sat in the chamber before me. There's nobody in the current council who sat in the chamber longer than Council Finn, so I'd be inclined to defer on his motion and be supportive of it to allow Mr. McRitchie to speak, but I wouldn't do so if you felt that that would somehow